Thank you for your attention to this brief overview of the immigration court and asylum process. After this video, you will be receiving an individual consultation with an immigration attorney about your specific case. There are many groups in the immigration system in the United States. This can be confusing. We would like to tell you a little about each group and what they do. The first group is Customs and Border Protection, or CBP. These are the officials you may have dealt with at the border. They may have asked you questions about why you are afraid to return to your country of origin. They may have permitted you to enter the United States, but they do not decide whether you can lawfully remain in the United States. The next group is the Immigration Court, sometimes called EOIR. This is where the U.S. government has started an immigration court case against you. The judge in the immigration court will decide whether to grant you asylum so that you can remain lawfully in the United States. The next group is called Immigrations and Customs Enforcement, or ICE. This group is like the immigration police. They keep track of people who are in the United States without papers. They sometimes arrest and detain people who have committed a crime. You may be required to go to an ICE office for check-in appointments. This is different from immigration court. The last group is called United States Citizenship and Immigration Services, or USCIS. This group decides some types of immigration applications, like applications for immigration status, work permits, green cards, citizenship, and sometimes asylum. When you entered the U.S., you were either apprehended from the interior of the U.S. or you requested asylum at a port of entry. You may have been interviewed in what is called a credible fear interview about why you are afraid to return to your country of origin. Or you may have simply been given documents, including a document called a Notice to Appear, or NTA. Some people may also have been given a card with the word paroled on it. These documents mean you have been allowed into the U.S. to request asylum or other humanitarian status. It is important to understand that you have not actually applied for asylum yet. Applying for asylum requires submitting an asylum application form to the immigration court. This asylum application is called Form I-589. It must be received by the court within 1 year of your entry to the U.S. You have not yet been granted asylum or any permanent benefit or status in the United States. For some individuals entering the U.S. at certain points of entry, there is a new process in which you may have already been interviewed for asylum by an asylum officer and then referred to the immigration court. If you think this applies to you, your situation may be different. So please talk to the attorney about this during your consultation. Removal proceedings is the process that the United States government starts in immigration court to remove you from the United States. Removal proceedings officially begin when the government files the paper called the NTA with the immigration court. The NTA contains important information such as the immigration charges against you, your identification or A number, the letter A followed by 9 numbers, and possibly the time, date, and place of your first hearing in court. Even if your NTA says a specific time, date, and place of your first hearing, it will often change. You can defend your case in immigration court by showing the judge that you qualify for an immigration benefit, like asylum, to legally remain in the United States. You will get a notice in the mail from the immigration court telling you the time, date, and place of your first hearing. The immigration court is located at 100 Montgomery Street or 630 Sansom Street in San Francisco. Here is a picture of the court building on Montgomery Street. You will go to the 8th floor if your court is on Montgomery Street, or the 4th floor if your court is on Sansom Street. It is very important that the immigration court has your current address. The immigration court will use this address to send you important documents in the mail, such as the date of your next hearing. If you move, it is your responsibility to update the court with your new address within 5 days. You can use the Form E33 to do that. If you miss a hearing because you did not update the court with your new address, you could be ordered deported. You can check on your hearing information by calling 1-800-898-7180 and entering your A number. We suggest calling every 2 weeks as the hearing dates do change often. If your first hearing is not scheduled in San Francisco, you need to ask for your case to be moved to San Francisco. If you need to update the court with your current address or you need to move your case to San Francisco, please let us know and we can help you do that today. There are 2 types of hearings in immigration court: master calendar hearings and individual hearings. Master calendar hearings are the initial preliminary hearings where you will update your address, indicate if you have a lawyer or not. You can request more time if you do not have a lawyer, and state what will be your immigration relief. The judge will set the date of your individual hearing. The judge will not hear the details about your case at the master calendar hearing. There could be multiple master calendar hearings until the judge schedules your individual hearing. If you do not have a lawyer, you should document all your attempts to get one to show the judge and ask for more time. The individual hearing is the final hearing. This is when you will present your testimony, evidence, and witnesses. The judge will decide whether you qualify for immigration relief. The individual hearing can be several days long if your case is not completed in one day. It is very important that you show up to all hearings, even if you do not have an attorney. If you fail to attend, you could be ordered deported. If you have minor children who are part of your immigration case, they also must attend at least the first hearing. The judge will tell you whether your children are excused from attending future hearings. You have the right to hire an attorney to represent you in immigration court. The government will not provide you with an attorney. You can try to find a free attorney, though capacity is limited, or you could hire a private attorney. You also have the right to represent yourself without an attorney. Because asylum laws are complicated, statistically, you have a greater chance of winning your case if you have an attorney. There should always be an interpreter available to help you communicate with the judge. You may also receive a letter in the mail telling you to meet with an ICE officer for a check-in. ICE officers can require you to wear an ankle monitor or require you to send a picture of yourself every week using an application that they will put on your phone. ICE check-ins are different from immigration court hearings, and they are usually in a separate building from the immigration court. You must attend ICE check-ins in addition to your immigration court hearings. You can apply for asylum in immigration court. If the immigration judge grants you asylum, you will have status to remain in the United States and later apply for permanent residency or a green card. You can apply for asylum if you cannot return to your country of origin because you have been harmed or fear being harmed in that country if you return. The reason you are harmed or fear being harmed must be because of your race, religion, nationality, political opinion, or membership in a particular social group. Remember, you must apply for asylum with the immigration court within 1 year of arriving in the United States. This means that if you entered the US on December 1st, 2022, you must submit your asylum application to the court on or before December 1st, 2023. These are some common claims that we see from people seeking services through our office. The strength or weakness of a claim depends on many factors, and an attorney can help assess this through consultation. Some claims that we see include people escaping domestic violence from their partner or spouse in their home country, problems with cartels or gangs who threaten family members, threats based on political activity in the home country or forced political party membership, threats or violence based on sexual orientation or gender identity, and threats based on a person's occupation, business, or property ownership. There are also many other types of claims, and a qualified immigration attorney can help assess this. You need a work permit to legally work in the United States. To be eligible to apply for work authorization, you must have some pending immigration application. If you file an asylum application with the immigration court, you can apply for work authorization with USCIS 150 days or about 5 months after you file your asylum application. USCIS can give you a work permit 180 days or about 6 months after you apply for asylum, but the process usually takes longer. Some people may have a master calendar hearing while they are waiting for the 150 days after they filed their asylum application in order to apply for their work permit. If this happens, and if you ask the judge for more time to find a lawyer, the asylum clock will stop. This means the days stop counting toward your work permit eligibility, so you may not be able to get a work permit. If you are given a card that says parole on it, you can apply for work authorization with USCIS right away. But your work authorization will expire when your parole expires. It is more common to apply for work authorization through a pending asylum application than parole. It is important to keep all important information and documents related to your immigration case together in a safe place, especially your NTA document and your parole card if you were given one. It is also important to keep copies of anything you file with the immigration court or with USCIS. We hope you have found this video helpful. You will now receive an individual consultation with an immigration attorney about your specific case. If you have questions about any of the information presented in this video, please ask the immigration attorney. Please remember that while you may choose to hire an immigration attorney, either at a nonprofit or a private attorney at your own expense, you must attend all hearings in your case, even if you do not have an attorney. Failure to appear at any immigration court hearing can lead to you being ordered deported in absentia or in your absence. Thank you.